Alright. Florida Department of State Division Corporation, Florida Non-for-Profit Corporations Act. 617-1501. Authority for foreign corporation to conduct affairs required. A foreign corporation may not conduct affairs within the state until it obtains a certificate of authority from the Department of State. The following activities among those do not constitute conducting affairs within the meaning of the subsection: maintaining, defending, or settling any proceeding held in meetings of the Board of Directors, member of the carrying and other activities concerning internal corporate affairs, maintaining bank accounts, sewing through independent contractors, and soliciting obtain orders whereby mail or through email agents, otherwise, if an order requires acceptance outside of the state before they become contracts. Creating and acquiring indebtedness mortgages, security interests of the real and personal property, securing and collecting debt for the enforcing mortgages, security interests of the property and securing debts, conducting affairs for the interstate commerce, conducting isolated transactions that is completed within 30 days, that is not one of the courses of the repeated transaction like nature. Opening and controlling subsidiary corporations in accordance with the transaction business with the state and voting with the stock of any corporation which is lawfully acquired. K. Owning the limited partnership interest of the limited partnership that is doing business with the state unless such limited partners manage with the control of the partnership, exercise the power of the duties of general partner. Owing without more real personal property living activities in subsection section 2 and not exhausted. This section has no applicable questions whether the foreign corporation is subject to service of the suit within a suit in the state under any law of the state. 617-1502. Consequences for the conducting affairs without authority. A foreign corporation conducting affairs within the state without a certificate of authority may not maintain proceeding in any of the court of the state until it obtains a certificate of authority. The successor of the foreign corporation that conducted the affairs in the state without the certificate of authority assigning with the cause of the action arising out of the affairs that may not make proceeding a base for the cause of the action in any of the court of the state until the foreign corporation and its successor obtain certificate of authority. A court may stay proceeding with the commencement of the foreign corporation or the successor assignee until the it determines whether the foreign corporation successor required for the certificate of authority. If it determines that the court may further stay proceeding until the foreign corporation and its successor obtain the certificate. For a foreign corporation which conducts its affairs with the state and this state without authority, that do shall be liable for the state of the year's part therefore during the conducting of its affairs in the state without authority, if it is amount equal to all the fees and the taxes which have been imposed by its own upon such a corporation that is duly applied and received such authority for the conduct of affairs in this state as required by this action. In addition to the payments thus prescribed, such corporation shall be liable to civil penalty not less than $500 more than $1,000 each year. The part of therefore during which is conducted with affairs in states without certificate of authority, the Department of State may collect all penalties under the subsection. Notwithstanding 1 and 2, the foreign corporation to obtain certificate of authority does not impair the validity of any of the contract deeds, mortgages, security interests, corporate acts, and prevent it from the defending any proceedings in the state. 617-1503. Application for the certificate of the authority. One foreign corporation may apply for the certificate of authority to deal with the affairs of the state, delivering the application to the Department of the State. For the following, such application shall be made with the form prescribed and furnished by the Department of State set forth in the name of the foreign corporation. If this name is available for you for the state, and the corporation may name that satisfies requirements of Statute 617-1506. Jurisdiction under the law which is incorporated the date and incorporation period of the duration, the purpose or purposes which intend to pursue the state, and a statement that is authorized with the pursuit of the state such private purposes and the purpose of the jurisdiction and corporation. E. The street address of the principal office, the address of the registered office in the state, the name of the registered agent at the office, the name of the usual business address of its current advisors, directors, and officers. 8. Such additional information may be necessary or appropriate in order to enable the Department of State to determine whether such corporation is entitled to file the application for the authority to conduct affairs within the state, to determine the assets and fees for the taxable pay as prescribed in this action. Foreign corporations should deliver with a completed application certificate of existence and documented with a similar import with a duly authenticated within the 90 days prior to the date. Delivery application to the Department of Secretary of State, other officials having custodial corporate records in the jurisdiction under the law, which is incorporated the translation of the certificate under the oath of the translator must be attached to the certificate in that it's the language other than the English language. A foreign corporation may not be denied authority to conduct its affairs within the state by the reason of the fact of the laws of the jurisdiction under which such corporation is organized governing its organization or internal affairs differ from the laws of the state. 617-1504, amendment of the certificate. Foreign corporation authorized to conduct the affairs of the state may application with the Department of State to obtain the amendment of the certificate of authority and change the corporate name, period of duration, the purpose of the purposes which intend to pursue in the state of jurisdiction and incorporation. Such application shall be made within 90 days after the occurrence with any of the change with commensurate in subsection 1 shall be made from the forms prescribed by the department and shall be executed filed with such a same manner as the original application for the authority and set forth. The name of the foreign corporation appear from the Department of Record of the jurisdiction of its incorporation the date of its authorized conducting its affairs in the state. If the name of the foreign corporation has changed the name, the relinquish the name of the state that change within the name has been effective within the law of the jurisdiction with the incorporation date of the change effected. The period of duration has changed. A statement of such change of the date of the change was affected. The jurisdiction corporation had the change and statement of such change of the date of the change was affected. If for the purpose of the corporation intend with the pursue the state with a change with the statement with the new purpose of the first statement, have the corporation authorized to pursue such purposes, jurisdiction and corporation requirements of statute 615-1503 with obtaining the original certificate authority applying for the obtaining an amendment certificate under the section 1505. Effective of certificate of authority. Certificate of authority authorizes foreign corporations which issue with the conduct and affairs of the state, subject about, however, the right of the Department of State to suspend and revoke the certificate is provided within this act. The foreign corporation's valid certificate of authority has some but no greater rights and the same no greater privileges except with otherwise provided by the act is subject with the same duties, restriction, penalties, liabilities now or later impose the domestic corporation like character. 3. This act does not authorize the state to regulate the organization internal affairs of the foreign corporation authorized to conduct the affairs in the state. 16-1506. Corporate name of the foreign corporation. A foreign corporation may not file for the application certificate authority unless the corporate name of such corporation satisfies the requirement of Statute 617-0401 to obtain the maintain certificate of authority to transact business in the state for the corporation. Or state or the foreign corporation may add the word with the corporation incorporated with abbreviation corporate or incorporated or INC word with the important which clearly would indicate with the corporation instead of the natural person partnership with the other business entire entity. However, the name of the foreign corporation may not contain the word company or abbreviations company. Many use the alternate name of the transact business name with the real name of the available with the name of the alternate corporate name and adopted with the use of the state with the cross reference for the real corporate names and records of the division of corporation. A real corporate name with the corporation becomes available to the state with the corporation changed its alternate name. Copy of the resolution of board of directors changed the withdrawal of the alternate name that executed with required in statute 617-101201 must deliver to the filing. The corporate name including the alternate name of the foreign corporation must be distinguishable with the record of the division corporation from any corporate name of the corporation for the profit incorporated authorized with the transact business in the state. Alternate name of another foreign corporation authorized in transact business in the state. Corporate name of the nonprofit, the corporation incorporated with the authorized to transact business in the state. The names of all the other entities fitting with the exact fictitious name or registration with the pursuant to statute 86509. Organized, registered under the laws of the state and that are on the file with the division of corporation. If the corporation authorized with the transact business with the state with the change of the corporate name with the one that does not satisfy the requirements of the statute 617-0401 with such corporation may not transact business in state under the change until the corporation adopt the name and satisfy the requirements 617-0401. Or your registered office, the registered agent for the foreign corporation. Each foreign corporation authorized to conduct the affairs of the state must continuously maintain in the state the registered office may be the same as any of the other places in the conduct of affairs of the registered agent, who may be individual arising from the state whose business office is identical with the registered office document. Domestic corporation for the profit, non for the profit of the office, business office which is identical with the registered office. The forest corporation for the profit, the non-profit, the authorized transaction business conducting its affairs in the state of the business, which is identical with the registered office. Registered agent office pursuant to the section successor registered agent appointed pursuant to statute 617-1508 with whom process may be served in each of the file statement written within the Department of State in such form the manner shall be described in the Department accepting employment of registered agent simultaneously his or her being designated such statement with acceptance for the state of the registered agent and the familiar with the acceptable obligation for the position. 617-1508, changing of the registered office, the registered agent of the foreign corporation. Foreign corporation authorized to conduct affairs in the state may change with the registered office, the registered agent by delivering the Department of State and the following statement change with the set forth its name, the street address of the current registered office. The current registered office is to be changed with the street address, the new registered office name of the current registered agent with the current registered agent is to be changed with the new registered agent, the new agent's written consent, either the statement or attached to it, an appointment that after an changes and the changes are made, the street address registered office and the business office registered agent will be identical. That any such change be authorized with a resolution duly adopted by the Board of Directors, officers, and corporation authorized by the Board of Directors. Registered agent change with the street address, his or her business, she may change street address with the registered office of any of the foreign corporation which he or she, the registered agent, notified the corporation in writing with the change of the decision, I think either manually or facsimilely delivering the Department of State following statement changing the complied with the requirements of paragraph 1A through 5 and the recite if the corporation has been notified and changed. 617-1509, resignation of the registered agent for foreign corporation. Registered agent for the foreign corporation may resign for his or her agent for the appointed by the signing of the delivering the Department of State following the statement of the resignation, mailing the copy of the statement of the corporation at the corporation principal office address shown in its most recent annual report, if none shown in its application certificate of authority, or the most recently filed document. The statement of the resignation may state the copy of such a statement has been mailed in the corporation to address. The stated statement of the resignation may include the statement of the registered offices, also continued. The agency get amended with the terminated within the 31st day of after the day of the assignment and filed unless the otherwise provided in the statement of termination of the agency acts against the termination for the registered office. 617-1510, service of process notice the domain of the foreign corporation. Registered agent of the foreign corporation authorized to conduct the affairs within the state is the corporation agent for the service of the process notice domain required for the permit by law to serve the foreign corporation. Foreign corporation may be served with registered certified mail in the return with the receipt with a request for the address for the Secretary of Foreign Corporation Principal Office showing an application for the certificate of authority and most recent annual report of the foreign corporation. Has no registered agent cannot be the reasonable diligence be served. Has withdrawn with the conducting of its affairs within the state under Statute 617-1520, has the certificate of authority revoked under Statute 617-1531. Service perfected under the subsection 2 of this earlier, the date of the foreign corporation received the mail, the date shown on the return receipt if signed on the behalf of the foreign corporation. C, the 5 day for the deposit in the United States and evidence for the postmark if mailed with the postmate paid and correctly addressed. The section does not prescribe only the means, the necessarily required means of the serving of the foreign corporation process against any foreign corporation may also be served in accordance with Chapter 48 and 49. Any notice of demand for the foreign corporation made pursuant to this act may be made in accordance with the procedure of the notice or the demand of the domestic corporation under Statute 617-0504. 617-1520, withdrawal of the foreign corporation. Foreign corporation authorized to conduct the affairs of the state may not withdraw from the state with the will until obtained the certificate of withdrawal from the Department of State. Foreign corporation authorized to conduct the affairs of the state may apply with the certificate of withdrawal delivering the application to the Department of State. With the following, the application shall be made with the forms prescribed and furnished by the Department of State and set forth. Name of the foreign corporation, the jurisdiction under law which is incorporated, the non-conducting the affairs within the state and the surroundings and its authority to conduct its affairs in the state. The revoked authority registered against a registered agent of the accept the service on behalf of the appointment of the Department of State agent for the service of the process for the cause of the action against during the time the authorized conduct of affairs within the state. A mailing address to which the Department of State may copy and mail and process served on the under paragraph C of the and a commitment to notify the Department of the State further of any change of the mailing address. After the withdrawal of the corporation, effective to serve with the process of the Department of State under this section to serve with the foreign corporation upon receipt of the process of the Department of State shall mail the copy of the process of the foreign corporation with the mailing address set forth under Section 2. 615.15.30 grounds of the revocation authority of the to conduct affairs. The Department of State may commence with the proceeding of the statute 617.15.31 to revoke the certificate authority of the foreign corporation authorized to conduct its affairs within the state. Foreign corporation is filed and files an annual report with the Department of State with the 5th of 5 p.m. Eastern Time on the third Friday in September. The foreign corporation does not pay with the time required with the act of May any fee for the taxes, penalties imposed with any other act of law of the foreign corporation without the registered agent or registered office in the state of 30 days or more. Foreign corporation does not notify the Department of State under the statute 617.15.08 and 617.15.09. The registered agent has resigned, but the registered office has been discontinued until 30 days after the date of the resignation of the discontinuance, and incorporated with the director, officer, or agent with the foreign corporation signed with the document he or she knew the false and material respect intent with the document delivered to the Department of State for filing. The Department serveth receive duly authenticated certificate of the State Secretary of State other having the custody of the corporate records in the jurisdiction under the law which of the foreign corporation incorporated, stating that it has been dissolved and disappeared with the result of the merger. The foreign corporation has been filed with an answer truthfully and fully with the time of the prescribed in the act of interrogatories propounded by the Department of State, procedural and for effective and effective revocation 617.15.31. If the Department of State determines one or more grounds exist in Statute 16.15.30 with the revocation certificate of authority, the Department of State shall serve with the foreign corporation notice of the intent to revoke the foreign corporation certificate of authority. If the foreign corporation has provided with the Department with electronic mail with such notice with the electronic transmission revoked from the failure of the final annual report shall occur with the fourth Friday of September each for the year, the Department of State shall issue a certificate of the revocation of each of the revoked corporation issued with the certificate of revocation made by the electronic transmission to any of the foreign corporation that has provided with the Department with electronic mail address. If the foreign corporation does not correct each of the ground revocation of the statute 617.15.32 through 7 or demonstrate the reasonable satisfaction of the Department of State each for the ground determined that the Department of State does not exist within 60 days after the issuance of the notice, the Department of State shall revoke the foreign corporation certificate of authority by issuing a certificate of revocation that recites the grounds for the revocation. Effective date issuance of the certificate of revocation may be the electronic transmission foreign corporation that has provided with the Department with electronic mail address. The authority of the foreign corporation conducts its affairs in state that sees the date of the shown certificate. Revocation of the certificate of authority. Revocation of foreign corporation certificate of authority does not terminate the authority of the registered agent of the corporation. 617.15.32 appeal for the revocation. If the Department of State revokes the authority of the foreign corporation to conduct the affair for the pursuant of the provision of the Act, for such foreign corporation may likely appeal with the circuit open with the county within the registered office of such of the corporation in the state situated by the filing with the clerk in such court with the petition setting the fourth copy of the application for the authority to conduct its affairs in the state of the copy of the certificate of revocation given to the Department of the State, whether upon the matter of the shall be tired of the de novo with the court shall either be sustained with the action of the Department of State and the directive of the Department to take such action that the court deems proper. Appeals of all the final orders, judgments entered for the circuit court under this section is reviewed with any of the ruling division of the Department of State has been taken in the other circuit civil actions. 615.15.33 reinstatement following revocation. Foreign corporation whose certificate of authority has been revoked under 1617.15.31 may apply with the Department of State reinstatement anytime after the effective date of the revocation authority. The application recite the name of the corporation and the effective date of the revocation authority. State the ground and the grounds of the revocation that either does not exist or have been eliminated, that no further grounds currently exist for the revocation of the authority. State the corporation as name satisfied with the requirement of statute 617.15.06. States all fees owed by the corporation computed with the rate provided with the law at the time the corporation applied for the reinstatement has been paid. It's an alternative. The foreign corporation may also submit the current annual report signed by the registered agent and officer director, which substantially complies with the requirement of paragraph A. The Department of State determines the application contained the information required for the subsection with the information correct with the shall file with the cancel with the certificate revocation authority reinstate the foreign corporation effective at the date in which reassessment document is filled. And when the reinstatement is effective, relate the back to the takes effect of the effective date. The revocation authority of the foreign corporation requirement assumes carrying on its affairs as if the revocation authority has never occurred. 4. Name of the foreign corporation who the certificate of authority has been revoked, not shall available the assumption for the use of another corporation until the 1 year after the effective date of the revocation of authority, unless for the corporation provide the Department of State with an affidavit executed as required in Statute 617-01-201, permitting the immediate assumption of the use of the name of another corporation. If the name of the foreign corporation has been lawfully assumed in the state and another corporation, the Department of State shall require that all the foreign corporations comply with Statute 617-1506 before accepting the application for the reinstatement. 617-1601 Corporate Records. A corporation shall keep the records of the minutes of all the meetings of members of the board of directors, with the record all the actions taken by the member of the board of directors without a meeting, and the record shall also contain the taken by the committee of the board of directors in place of the board of directors that have become behalf of the corporation. 2. The corporation shall maintain the accurate record. 3. The corporation agent shall maintain the records made members in the form of the permits of the preparation of the list, the name and address of all the members applicable order by classifying the vote of the members. Corporation shall maintain the records written from the form and another capable of the conversion into the written form of the responsible time. A corporation shall comply, keep a copy of the following records are an article into operation and restated articles in corporation, all amendments that currently affected. B. And its bylaws and restated bylaws, all the amendments that can currently in fact with the minutes of all the members meeting will record all action taken by the members without meeting for the past 3 years. Written communication to all the members that generally all the members of the class within the past 3 years, including the financial statement furnished for the past 3 years under Statute 617-1605. List of names and business and streets, home if there's no business street or address if in the current director's office. Its most annual report delivered to the Department of State under Statute 617-1622. Alright, 617-1602, inspection of the records by members. Member of the corporation entitled to inspect and copy during the regular business hours of the corporation principal of the reasonable location with the specified of the corporation, A, with the records of the corporation described in Statute 617-1601-5. If the member gives the corporation written notice that his or her demand is at least 10 business days before the date of which he or she is wishes to inspect the copy. Alright, a member of the corporation entitled to inspect the copy during regular business hours with a reasonable location specified by the corporation. Any of the following records the corporation members meet with the requirements of subsection 3. Give the corporation written notice that his or her demand within 10 days, at least 10 business days before the date of when he or she inspects it and copy. Expert from the minutes of any meeting of the Board of Directors records action of the Committee of the Board of Directors while acting with the place of the Board of Directors on behalf of the corporation. Minutes of any meeting of the members recorded of the action taken by the members of the Board of Directors without meeting the extent not subject to the inspection under the subsection. 1A, 1B, accounting record of the corporation. 1C, the record of the members. D, any other books or records. 3, a member of the inspection copy of the records described in Section 2 only. A member of the demand. A. The member of the demand is made with a good faith and proper purpose. B. The purpose the member described in the reasonable practice of the purpose of the records he or she desired to inspect. C. The records are directly connected with the member's purpose. 4. The section does not affect the right of the member litigation for the corporation to inspect the copy of the records to the same extent with the litigation. The power of the court, and independently with this chapter, of the compel with the production of the corporate record for the examination, the corporate may demand or deny any demand for the court inspection pursuant to subsection 2 if the demand was made with the improper purpose, or if the demand member has been within 2 years proceeding of his or her sold offered for the sale of any list of the members of the corporation, any other corporation is aided and abetted with any person in procuring a list of any of the members from each for such purposes and proper need for the use of information secured through any of the prior examination of the records of corporation of any other corporation. For purposes of the section, the term the member that includes the beneficial owner which shares and held the voting trust of the nominee on his behalf. For the purpose of this section, proper the purpose of means for the purpose responsible or related to such person interested in a member. 617-1603, the scope of the inspection right. The member, the agent with the attorney has the same inspection copy rights as the member he or she represents. Right to copy under the statute 617-1602 includes the responsible right to receive the copies made with photographic directs or other means. The corporation may impose the responsible charge, cover the cost of the labor and material for the other copy of the documents provided with the member. The charge must not exceed the estimated cost of production or reproduction of the records. If the records are all kept in the other with written form, the corporation shall convert with such records into the written form of the upon request any member entitled with the inspection, the corporation shall bear the cost of converting any records described in Statute 617-1601-5. The request of the member shall bear the cost, including the cost of complying with the information requested incurred with the converting any of the records described in 1617-1602. 4. If requested by the member of the corporation to comply with the member of the demand inspection and records of the members within the statute 617, 16022, C, and then providing with him or her with the lease of the member of the nature of the duty 1617, 16013, shall list the complied with the last record of the date with which has been compiled of the word is subsequent to the date specified by the member. Or at 617-1604, court-ordered inspection. If a court ordered, and if the corporation does not, within reasonable time, allow the member to inspect the copy of the record, the member complies with any of the prerequisite inspection composed by the inspection copy. The member may apply with the circuit court of the county with whether the corporation principal officer, if none of the state, the registered office is located in or for an order with the permit inspection copy of the records demanded. The court shall dispose of the application under the subsection with expedited but summary basis. If the court orders inspection copy of the records demanded, it should also order the corporation custodian and the custodian particular record the demand with the pay of the members of the conflict, including reasonable attorney for reasonably in order to obtain the order of enforcement of the rights under this section, unless the corporation or the officer, director, or agent, as the case may be, provides that he or she refused inspection in good faith because he or she is responsible to base it out about the right of the member for the inspection of the copy of the rights demanded. If the record of the order inspection copy of the records demanded, it may impose a reasonable restriction on the use of the distribution of the records demanding by the demanding member. 617-1605, financial reports of the member. The corporation, upon a member's written demand, shall be furnished for the member the latest annual financial statement, which may be consolidated, combined statement of the corporation, one or more of the subsidiary affiliates appropriate with which to include the balance sheet at the end of the fiscal year of the statement, the operation for the year financial statement prepared with the corporation on the basis of generally accepted accounting principle. The annual financial statement must also be prepared on such a basis. 617-1606, access to records. Section 1617-1607, 1617-1605 do not apply with the corporation that is an association defined in statute 720-301 or a corporation regulated under chapter 718 and chapter 719. 617-1622, annual report of the Department of State, each for the domestic, each for the foreign corporation authorized to conduct the affair of the state, deliver to the Department of State, following the sworn annual report, such as the Department of the State, to prescribe the set forth the name of the corporation and the state of the county under the law of which is incorporated. The date of the incorporation, foreign corporation, the date of which is admitted for the conduct of the affairs of the state, the address for the principal office, the mailing of the address for the corporation, federal employer identification number, if any or if none of the others one has been applied before, name of the business, street address for the directors and principal office, street address for the registered office in the state, of the name of the registered agent of the office, and such additional information that may be necessary and appropriate to enable the Department of State to carry out the provision of this act. The deposit of such a report on before the May 1st of the United States, mail the sealed envelope properly addressed with the postage paid with the customs institutes compliant with subsection 1. If an annual report does not contain the information required in subsection 1, the Department of State shall properly notify the required reporting domestic foreign corporation writing with a return of the report with the correction of the if the reporting corrected with the contains information required with the subsection 1 the Department and delivered by the Department of State within 30 days after the effective date of the notice is deemed timely filed. For each annual report must be executed by the corporation officer or director, or if the corporation of the hands received with the trustee must execute on behalf of the corporation by the received with the trustee. Signing with the annual report shall have the legal effect of the may be out within the necessity of the appending of the such oath of the oath thereto. The first annual report must be delivered to the Department of State between January 1st and May 1st of the following year, calendar year in which the domestic corporation was incorporated, but the following corporation was authorized to conduct affairs. Subsequent annual reports must be delivered to the Department of State between January 1st and May 1st, subsequent calendar years. Information for the annual report must be current as the day of the annual report is executed on the behalf of the corporation. If an additional report is received, the Department of the file of the document may be the information contained therein in the official record. Any corporation failed to file an annual report shall comply with which complied with the requirements of the section and may not maintain or define any of the action of any of the state until such a report is filed with all the fees, tax dues under this action are paid with the such corporation is subject to dissolution, cancellation, certificate of authority to conduct affairs and provided with this act. The Department shall prescribe the forms which make the annual report called by the section of the substitute with the uniform business report with the pursuant statute 60606 means for the satisfying requiring the section. All right, 617. 1623, corporate information available to the public application for the corporation, corporate of the circuit court for the special act of the legislature. Each corporation, corporate of the state, maintain the registered agent, registered office in accordance with the statute 617-0501. Current information regarding the corporation, corporate of the state, which shall be readily available to the public. A minimum of such information must include text for the charter, article for the incorporation, all the amendments in the name of the corporation, the date of the incorporation, the street address for the physical principal office of the corporation federal employer, identification, the number, the name of the business, and the street address for each for the officer, the business street address for each for the director of the name of the registered agent, the street address for the registered office. Any corporates which have the charter approved with the circular or judge for the under the form of the for chapter 617, the statute 918, 1918 of the charter granted with the legislature on before the September 1st, 1959, the effective date of chapter 59, 427. Laws of Florida must file with the Department of State no later than July 1st, 1992. Copy of the charter and all attachments thereto, the certified by the clerk of the circuit court of the county wherein record together with registration containing the provision in paragraph A of the charter of the amendments granted by the circuit judge by the Department of State, the legislative charter of the corporation, and thereto must be subject to the requirements of statute 617, 150501, 617, 1622. Any such corporation with fails to comply with the paragraph B within non-exempt requirements, therefore, of subsection 2 is in July 2nd, 1992, and dissolved, and thereby after may not maintain the defendant that any of the action in any other courts in the state. D. Any corporation dissolved pursuant to paragraph C of the reinstatement upon the application of the Department of State signed by the officer or director thereof of the company with a copy of the charter of the member thereto, the case certified by the clerk on the circular court of the county wherein recorded as the chair of the amendment granted by the circuit judge, the Department of the State as the legislative charter together with the registration containing the provisions required from the paragraph A of the payment for all the fees due at the time of the dissolution computed with the rate provided by the law of the time of the corporation applies for reinstatement. Whenever the application for the reinstatement is approved by the file of the Department of State, the corporation existing shall be deemed to have continued without interruption from the day of the dissolution. The reinstatement terminates the personal liability of the directors, officer, or agent of the corporation incurred by the account of the action taken during the period of the between dissolution and reinstatement. Reinstatement of the corporation shall be subject to the requirements of statute 617-0501 and 1622. Any corporation which has been reincorporated under 617-091 0901, former 617-012, Florida Statute 1989 is exempt from the requirements of this section. Alright, 617-1701, application existing domestic corporation. The act applied for all domestic corporations existing in July 1st, 1991. They were incorporated with the general statute of the state, with provided within corporation for power for profit demanded with the repeal of the statute under which the corporation was incorporated and reserved. 617-1702, application qualified foreign corporation. A foreign corporation authorized to conduct affairs within the state with July 1st, 1991 is subject to the act and not required to obtain the new certificate of authority to conduct affairs under this act. And 617-1703, application for the chapter. If in the event of the conflict between the provisions of the chapter of this chapter and chapter 718 in regard with the condominium of the chapter 719 in regard with the cooperative chapter 720 regarding the homeowners association chapter 720 regarding the time siren chapter 720 regarding the mobile homes association and provision of the such other charity chapters shall apply with the provision of statute 617-0605 through 617-0608. Does not apply with the corporation regulated with any of the foreign chapters with any of the other corporation with the membership and the corporation is required pursuant to a document recorded within a copy of the property with records. Alright, 617-1711, the application for the foreign interstate with commerce and commerce. The provision of the act applied with the commerce with the foreign nation among the several states within so far that such for the commerce must be permitted with the constitutional law of the United States. 1617-1803, domestic or foreign nonprofit corporation. The of this section, the term the nonprofit of the corporation includes the nonprofit incorporation organization. Foreign nonprofit the corporation may be domesticated in the state by filing with the Department of State. Certificate of domestication executed in accordance with subsection 7 filed in accordance with the 617-01201. Articles of incorporation executed and filed in accordance with the 617-01201 or 617-0202. Certificate of domestic certification shall the date which from the jurisdiction with the corporation first filed, no quarter incorporated otherwise came into being. The name of the corporation immediately being before filing the certificate of domestication. The name of the corporation set forth the articles incorporated the jurisdiction constituted with the seat with the seas, the social principal place for the business, central administration of the corporation, and any other equivalent jurisdiction under the applicable law immediately before filing the certificate of domestication. Upon filing certificate of domestication, any articles incorporated, the corporation shall be domesticated in the state and shall thereby subject to subjection Example is notwithstanding statute 617.0203 existing with the corporation of the name of the commencement of the day of the commencement existence of the jurisdiction in which the first form was incorporated with otherwise came into being. 5. The domestication by any non-profit of the corporation in the state does not affect any of the obligation and liability incurred by the domestication. 6. The denial of the certificate of domestication does not affect the choice of the law applicable to the corporation except that after the day the certificate of domestication is filed, the law of the state applied with the corporation to the same extent that it is to have been incorporated as a non-profit corporation of the state of the date on the date. Certificate of domestication shall be signed with the corporate officer, director, trustee, management partner, or other person performing the functions equivalent to those of the officer or director, however the name is described who is authorized to sign the certificate of domestication on behalf of the corporations. When the domestication becomes effective, the title of the real personal property, both intangible and intangible, of the foreign corporation remain the domestic corporation, and reversions and impairment of the liability of the foreign corporation remains liable of the domestic corporation. Active proceeding action against the foreign corporation continues against the domestic corporation if the domestication has not been occurred. The articles of incorporation attached with the certificate of domestication constitute the articles of incorporation for the domesticated corporation. Members' interests in the foreign corporation may remain identical in the domesticated corporation. 617-1805, the corporation for the profit may become the corporation for the non-profit. Any of the corporation properly incorporated under the law of the state engaged solely with the carrying out of the purpose of the object for the corporation, not for the non-profit, or any authorized under the state of law, carrying out with many change for the corporate nature for the corporation, for the profit of that the corporation, not for the profit is defined in the act of the buying fine, following a position with the circuit court of the county, with which may be principal for the office and located with the name of the corporation sign of the officer over of the corporation under the corporate seal setting for the purpose of the object in which the sole engaged with the question with the nature of the corporation to be changed. However, any of the corporation property that which has been transferred is in the process of the transferring function as with the corporation, not profit the proceeding under the acts of shall be the recital of the facts and circumstances, initiation, intention surrounding the transfer proceeding as in a petition filled in accordance with the statute 617-1806, subsequent approval thereby circuit judge to approve and presenting with the deemed that have been acted under the act such as the corporation non-profit shall succeed the rights for the liabilities as to the corporate predecessor. Alright, 617-1806, conversion of corporation from a non-profit petition contents. A petition for conversion of the corporation to non-profit pursuant to statute 617-1805 shall be accompanied by the written with the consent of the shareholder authorizing the change of the corporate nature for the direction of the authorized officer shall file with such a petition before the such court together with a statement agreeing to accept the property of the petition corporation and agreeing with assume the paying the indebtedness liabilities proposed an article of the incorporation signed by the president and secretary of the petitioning corporation which shall set forth provisions required in original articles of incorporation set by statute 617-0202. Alright, 617-1807, conversion of the corporation non-profit, the author ordered the circuit judge of the judgment whom the petition proposed the article of incorporation presented with the fund of the petition proposed article with the proper form he or she approved with the corporate article of incorporation and or his or her approval therein. Such approval should provide with all the property of the petition corporation shall become with the property of the successor corporation not for the profit subject to the indebtedness liability of the petitioning corporation. The articles on which the shall endorsement thereby shall be sent to the Department of State, which shall be upon receipt thereof them upon the payment of all the taxes due with the state petition corporation, if any of the youth certification shall receive with the articles and corporation endorsement approval thereof on the payment of all the taxes in the state upon the payment of the following fees specified in statute 617-0122 with the department of the shall file with the articles and corporation therefore the petition corporation shall become with the corporation non-profit under the name of adoption of the articles and corporation subject to all the rights and powers and immunities, duties and liabilities of the corporation non-profit under the state law, rights and powers, immunities, duties and liabilities of the corporation for the profit cease and determination. 617-1808, application of the act of the corporation converted with the corporation from the non-profit, all the provisions relating to the corporation non-for-the-profit exempt insofar that they are inconsistent with the statute 617-1805, 617-1806, 617-1807 shall be applicable to any corporation whose charter has been changed to 1617-1805, 617-1806, and 617-1807. Shall henceforth govern such a corporation. 16-1809, Limited Agricultural Association conversion with the domestic corporation non-profit. As used in the section, the term limited with the agricultural association. Association means a limited agricultural association form that statute 60409, 604 through 60414. Limited agricultural association cover the domestic corporation of the nonprofit filing the following documents for the department in accordance with statute 617-0102. The certification of conversion which must be executed with the person authorized in 617-01. 2016 shows other person may be required for the association articles, association bylaws, articles, and corporation must comply with the statute 617-0202 and be executed by a person authorizing 617-01-2016. Certification conversion must be included the date upon the actions association upon any initial form under the statute 607-09, 604, 13. Name the association immediately before leaving the certificate of the conversion the name of the domestic corporation set forth in the articles of incorporation. D. The effect of the delay of the conversion, but the conversion does not take effect upon the file of the certificate of the conversion article of incorporation. The delayed effect of the date of the conversion, subject to the limitation for the 617-01-23-2. There must be date with a certain same as the effective date of the articles of incorporation. Whenever the effective conversion article of incorporation filed with the department upon the delay of the fact the association converted with the domestic corporation, the corporation becomes the subject of the chapter. However, nothing withstand 1617-01-23 for the existence of the corporation deemed to have the commenced and when the association initially formed with the 60409 through 60414. Conversion of limited agricultural association and domestic corporation does not affect the obligation and liability of the association for the incurred with the conversion. When the conversion takes effect under this section, all privilege and power of the conversion association, all property, real, personal, makes, and all debts are due the association, as well as other assets caused the action belonging to the association are vested in the domestic corporation in which the association converted with any and are the property of the corporation and they were associating. The title of any of the real of the property vested in the deed, but otherwise converting the association does not revert and is not impaired with the operation of the chapter, but all the rights of the creditor and all liens upon the property of the association preserved and impaired. All the debts and liabilities due to the association act of the domestic corporation and or enforceable in the same extent within debts and liability due they have incurred with the contract of the corporation. Some limited agricultural association not required with the wind up with the favor of the pay liability to distribute in its asset. The conversion does not constitute the dissolution of the association, but is the continuation of the association's existence for the form of the domestic corporation. For limited agricultural association may file with the certificate of conversion of the department unless otherwise specified the association with the articles of association by law of the conversion must be approved. The major vote of the associated member of the articles of incorporation must be approved by the same with authorization required for approval of the conversion. As part of the approval of the converting of the association may provide with the plan of the record of the conversion may describe the manner based for the conversion of the membership of the interest of the association members of the interest of the domestic corporation. The plan of the record may also contain the provisions relating to the conversion, including not limited to the right of the conversion actions association to amend the proposed conversion with the effective date of the conversion consistent in paragraph 3D. Alright, 617-1904. Nobody for the person acting with the corporation shall be permitted to set up the lack of legal organization defense for the action against the corporation, nor shall apply with any of the persons sued with the contract date made with the corporation sued, but for injury or to its property wrongdoing with the interest permitted the setback and the lack of such for the legal organization for his or her defense. Or 617-1907, effective the repeal and amendment of the prior acts, except the provided in subsection 2 with the repeal of the amendment of the statute chapter does not affect the operation of the statute may act from under this repeal and amendment by any ratification, right, remedy, privilege of obligation, liability incurred, the liability acquired or incurred under the statute before its repeal and amendment of the violation statute with any of the pay penalty, forfeiture, punishment incurred because of the violation before the repeal and amendment, that the proceeding reorganization, dissolution commenced with the repeal and amendment, that the proceeding or reorganization or dissolution may be completed if they have not repealed or amended. And for penalty, punishment is imposed. The violation statute repealed and amended is the chapter reduced. This actual penalty for the punishment is already imposed shall be imposed in accordance with this chapter. 617-1908 application for the Florida Business Corporation except otherwise be made an applicable specific reference in another section of chapter provision chapter 607 of the Florida Business Corporation Act and shall not apply with the corporations of a nonprofit.